Let me begin by thanking Professors Weimar and Benhabib and Ned for this extremely kind invitation. It's been 20 years or more since I was last at the European University Institute. I have been here when Stephen Lux was still a professor. But now this year I was affiliated with the Strauss Center at NYU, where you have some of your most distinguished alums, such as Joseph Weiler and Grania de Borca, and not to speak of my own distinguished student, Türküler Işıksel, who was with you, I think, 2 years ago. Some of you may still remember her. So I haven't been here a while, but the connections persist. And I would also like to acknowledge Reiner's own very important book, Transnational Citizenship, which I very carefully read at the beginning of my own work on the rights of others. One more introductory comment and I'll start. I actually work from a text. I use PowerPoint to help along with certain passages and concepts. And I know that maybe English is not the first language for many of you, but sometimes I would recommend to listen to me and just look at the PowerPoint every so often, and sometimes I don't coordinate it. I mean, it's just a matter of, it's just a matter of scientific styles. And had I not been at the Wissenschaftskolleg in Berlin 3 years ago, I would have never thought that a philosopher had to use PowerPoint. But whatever helps the comprehension, we'll move along with it. Okay. The resurgence of cosmopolitanism. The last 2 decades have seen a revival of interest in cosmopolitanism across a wide variety of fields, ranging from law to cultural studies, from philosophy to international politics, and even to city planning and urban studies. How do we account for this? Undoubtedly, the most important reason for the shift in our sensibilities and cognitions are the epoch-making transformations referred to as globalization and the end of the Westphalian Keynesian Fordist paradigm by some, as the spread of neoliberal capitalism by others, and as the rise of multiculturalism and the displacement of the West by the rest by still other scholars. Cosmopolitanism has become a placeholder for thinking beyond the confusing present towards a possible and viable future. Legal developments are at the forefront of these transformations. It is now widely accepted that since the Universal Declaration of Human Rights in 1948, we have entered a phase in the evolution of global civil society, which is characterized by a transition from international to cosmopolitan norms of justice. While norms of international law emerge either through what is recognized as customary international law or through treaty obligations to which states and their representatives are signatories, cosmopolitan norms accrue to individuals considered as moral and legal persons in a worldwide civil society. By cosmopolitanism, I have in mind both a moral and legal proposition. Morally, the cosmopolitan tradition is committed to viewing each individual as equally entitled to moral respect and concern. Legally, cosmopolitanism considers each individual as a legal person entitled to the protection of their human rights in virtue of their moral personality and not on account of their citizenship or other membership status. Even if cosmopolitan norms also originate through treaty-like obligations, such as the UN Charter, the UDHR, and various human rights covenants can be considered to be, their peculiarity is that they bind signatory states and their representatives to treat their citizens and residents in accordance with certain norms, even when states later wish, as is often the case, to engage in actions which contradict these terms and violate the obligations imposed upon them by these treaties themselves. This is the uniqueness of the many human rights covenants concluded since World War II. Sovereign states undertake the self-limitation of their own prerogatives. Now, I'm not going to go through a list of, the best known of these, the Convention on Genocide, but just I will pull out a couple of numbers. The International Covenant on Civil and Political Rights, which was entered into force in 1976, has 167 countries out of 195 that are party to it in 2012. It's important to keep these numbers in mind. The International Covenant on Economic, Social and Cultural Rights has 160 state members out of 195 as parties to it. And the statistic that is most surprising, the International Convention on the Elimination of All Forms of Discrimination Against Women, what I will refer to as CEDAW, signed in 1979, entered into force in 1981, has 99 signatories and 187 state parties as of 2012. But the skeptic will ask, what does all this really mean? What possible significance can these multicultural human rights covenants have if states continuously and brazenly violate them, manipulate them to serve their own ends, etc.? Are they not mere words at worst or aspirational ideals at best that have little traction in influencing and limiting state conduct? Do these developments add a novel, enforceable, and justiciable legal world order? Doesn't the process of formulating what are called RUDs, reservations, declarations, and understandings, placed by states on these human rights treaties in particular, make them merely convenient smokescreens? I think these skeptical doubts about state behavior and an international system that remains beset by violence, civil wars, and proxy wars cannot be set aside. Nonetheless, I remain convinced that something has changed profoundly in the grammar and syntax of the language of international relations, sovereignty, and human rights. Just as repeated use may imperceptibly change grammar and syntax in a language, consider, for example, the frequent use of contractions, such as he apostrophe is, as for he is in English, or the use of the number 2 for TWO, the spelling out. Legal practice, just as language, through institutionalization and adjudication, may change legal doctrine. In an earlier work, The Rights of Others, I described such processes of transformation in the international domain through the use of a metaphor. I said we are like travelers navigating a new terrain with the help of old maps. While the terrain has radically changed, the terrain of Westphalian sovereignty, our maps have not. Thus, we stumble upon streams we did not know existed, and we have to climb hills we never have dreamt of. Mirroring these imperceptible but cumulative transformations of these last 3 decades, the status of international law and of transnational legal agreements with respect to the sovereignty claims of liberal democracies has become a highly contentious theoretical and political issue. Deep divergences have emerged among democracies normally considered allies. While Europe, under the cumulative impact of the jurisprudence of the European Court of Justice, the European Court of Human Rights, and strong constitutional courts such as the Bundesverfassungsgericht, has moved towards a cosmopolitan order of strong rights protection and harmonization of domestic laws with UDHR and other treaties, a strong isolationist current has become visible in the US Supreme Court. And part of my project now is really also looking at the status of cosmopolitan law within American law, but that's not what I'm going to talk about today. I'm going to paint a more general theoretical picture for approaching these questions. At least 2 different discussions dominate. First, what is the status of foreign law, including the law of other nations and international treaties, in constitutional and statutory adjudication? As we know, great variations across countries exist in this regard. While international law becomes part of the valid constitutional order in many countries, such as the Netherlands and South Africa, among others, and this is referred to as constitutional monism, other countries are dualist with respect to treaty-based international law, and require treaty ratification before these treaties can become part of the law of the land. And in fact, in the United States, nothing that has not been ratified by the Senate can become part of the treaty, and many international human rights conventions have not been, in fact, ratified by the US Senate. Now, a second controversy with which I know you are all very familiar is whether these recent developments in legal doctrine and practice can be seen as leading towards global constitutionalism with or without the state. Global constitutionalists point to increasing cooperation among constitutional court justices. They're learning from one another, and increasingly they're citing one another in similar cases, not as precedent necessarily, but as significant evidence. Even some scholars, such as Jeremy Waldron, who find the concept of global constitutionalism exaggerated, nonetheless have argued in a recent book that there is increasing convergence around a law for all nations. Surveying the legal writings of these last 2 decades on constitutionalization with or without the state, legal pluralism, constitutional pluralism, juridification in a world society, I have the impression that the law and legal scholarship today, much as they help to consolidate the gain of the interstate Westphalian Treaty of 1648, by providing the philosophical and jurisprudential basis of liberal bourgeois revolutions, that the law and legal scholarship today are anticipating a world that is yet to come, in verite affaire. Legal scholarship has become a utopian constitutive element in a new world that is yet to come, but which we as contemporaries can only grasp with the help of metaphors. By contrast, and I hope this will be a controversial claim, political science has lost its privileged object domain, namely the state and classical international state relations. This observation, I think, pertains both to so-called realist theorists, who take the unitary state as the principal actor for all reflection and investigation, as well as to liberal internationalists who have a more pluralist vision of the state and who analyze state behavior differently. Whether we think that states behave as self-interested principles or as agents and principles that are susceptible to normative and value considerations, the unit we are looking at has remained the same, the state and its institutions, whereas the new legal scholarship has disaggregated this unit. Political science, with few exceptions, has not yet taken note of these transformations. So my own questions as a political philosopher are related to, but distinct from, these issues. I'm interested in legal cosmopolitanism as it bears on the moral individual as a legal person in the international community, and I wish to examine the alleged conflict between one class of international legal norms in particular, namely those pertaining to human rights broadly understood and democratic sovereignty. I will argue that transnational human rights norms strengthen rather than weaken democratic sovereignty, and distinguishing between a concept and a conception of human rights, which I will elaborate, I will claim that self-government in a free public sphere and a free civil society is essential to the concretization of these necessarily abstract norms. My thesis is that without the right to self-government, which is exercised through proper legal and political channels, we cannot justify the range of variation in the content of basic human rights as being legitimate, and as Rainer mentioned, I call these processes democratic iterations. Now, let me begin by looking very briefly, and I will go over this rather quickly, one more time at the skeptical argument. And what I'm going to present are both some institutional insights and insights from political philosophy and jurisprudence this way. All right, let's move to my honorable colleague, Bob Dahl from Yale. Now, in a very influential article, Robert Dahl, in an article called "Can International Organizations Be Democratic?" a skeptic's view, answered with a resounding no. An international organization is not and probably cannot be democratic, he argued. Dahl defines democracy in a fairly conventional way as a system of human rights and popular sovereignty. The reason why he thinks that no international institution can be democratic are three. They have epistemic limits, problems of cultural diversity, and procedural factors. Now, by epistemic limits, Robert Dahl means that international matters are infinitely complex and beyond the understanding of the average citizen and necessarily require experts to handle these matters. But it is, though I don't believe makes the convincing argument as to whether this is a matter of kind or this is a matter of degree. Whether in fact international matters and issues are more complex than ordinary issues that democratic citizens have had to deal with, and this is an old argument. Now, the second argument about cultural diversity is that as the boundaries of the demos expand, that we have more and more heterogeneity leading to more and more cleavages, and therefore it becomes more and more difficult for citizens to identify with expected cultural interests. The third factor that Robert Dahl names is that in the international arena, the public good is contested and that we do not have proper procedural channels to be able to address what is considered the public good. My answer to Dahl in all these cases is a very simple one. Are these matters of degree or are these matters of kind? In other words, aren't existing democracies also afflicted by many of these difficulties, and why would we argue that there is such a radical or sharp break between the national and the international domain? There are now three different kinds of criticisms of Dahl that have been voiced by social scientists, and it's important for me to do this survey. I'm doing a survey before I get to my main argument, because I'm trying to, in some ways, point out to what's going on in the political science and sociology literature on these issues, as opposed to the more philosophical and jurisprudential arguments that I will address. There are three important criticisms of Dahl's position, which is, after all, a fairly state-centered, nation-state-centered position. The first is the thesis put forward by Saskia Sassen in many of her works, where Saskia shows by analyzing the micro-institutions of the state, from banking to finance to other forms of regulation, that the boundary between the national and the transnational is undermined by the state itself. This I refer to as the transformation of sovereignty. A second argument has been put forward by Bob Cohane, Stephen Macedo, and Andy Moravchik in an important paper called Democracy Enhancing Multilateralism. And what they actually claim is that participation in multilateral institutions defined as international organizations, regimes, and networks actually enhance the quality of democratic deliberation, because states then, by becoming subject to these treaties and conventions, then are self-controlling in terms of being consistent with the treaty requirements. He claims that minority rights are protected. I mean, think of what the European Court of Human Rights is doing for the rights of the Sinti, whether you agree with it or not. And they believe also that participation in such international institutions, such as the panel, the UN panel on climate change, counteracts populist tendencies, let's say, that would dismiss that in fact there is something called climate change going on. It is happening in the United States. So this is a strong argument about how international institutions help the quality of democratic deliberation. Now, a third empirical work in this area, which is quite important, is the work of Beth Simmons. What Beth Simmons has done is to try to analyze what difference it makes for democracies and non-democracies as well, when in fact they adopt international human rights treaties. And she claims to be able to show in some of her influential empirical study that in fact when a state ratifies a human rights treaties, that this creates a possibility, a channel for citizens and residents in these countries to use this language of human rights to militate for reforms on their own behalf, and also at the same time to create what she calls a nascent culture of human rights. And I will return to this thesis because I am in complete agreement with her, and I'll try to give this a more normative grounding. So, in view of these perspectives, I think that the question is rather different than the way Robert Dahl posed it in the late 1970s. Rather than being confined to the nation-centric demos, democracy itself may no longer be possible except as a project of state interdependence and global cooperation. I know within the European context this is not really news. You are trying to practice it, with good or bad results. And second, international organizations themselves need to be increasingly subject to multilateral criteria of democratic accountability and transparency, which Dahl himself does not deny, although he is skeptical about it. What I wish to do now, in the main part of my lecture, is I want to integrate legal scholars' contributions to this debate with certain normative considerations on human rights and democratic theory. I want to follow some of the theses presented above by elucidating a more philosophical approach to the interdependency of democracy and human rights. Human rights constitute the core of legal cosmopolitanism. Without clarifying the relationship of human rights treaties and international practices, much talk about legal cosmopolitanism hangs in the air. Now, when we turn to the contemporary philosophical debate on human rights, we see that there is a wide-ranging disagreement among contemporary philosophers about the philosophical justification as well as the content of human rights. Michael Walzer, for example, has argued that human rights are the center of what he calls a universal thin morality. Martha Nussbaum has argued that human rights constitute the preconditions of a world, reasonable conditions of a world political consensus. And I suspect that you are all familiar with John Rawls's famous argument in The Law of Peoples that human rights are a minimum standard of well-ordered institutions for all peoples. Now, not only is there divergence about the content and the list of human rights considered acceptable, there is also divergence among contemporary philosophers as to how you justify human rights. And I'm not going to engage in this question now, although we can talk about it in the question period, because this issue in itself requires maybe more than one lecture. Instead, I just want to state in very general terms my own understanding of human rights and then move to this interaction between transnational law and human rights, which is the center of this lecture. Human rights, in my view, constitute a narrower group of claims than general moral rights. So the general class moral rights and then human rights are a species of moral rights, but narrower. Human rights bear on concepts of human dignity and equality. They are protective of the human status as such. I agree here with the important work of James Griffiths that human rights do not exhaust the entirety of our conceptions of justice and morality. Rather, human rights have their proper place in discourses of political legitimation. Such discourses of political legitimation presuppose moral principles in the sense that the justification of human rights always leads back to some general moral principle and some conception of human agency. Human rights are central to a public vocabulary of political justice they designate in that sense a special and narrow class of moral rights. The World Human Rights Covenants and Declarations articulate general principles which need contextualization and specification in the form of legal norms. How is this legal content to be shaped? Basic human rights are rights that require justiciable form. They require legal content. They need embodiment and instantiation in a specific legal framework. In that sense, human rights straddle the line between morality and legality. They will enable us to judge the legitimacy of the law in the light of broader normative principles. It is important here to consider Habermas's observation about not making an all too hasty transition from human rights considered as moral principles to constitutional rights, to human rights when they become embodied as constitutional rights that are justiciable. I'm going to quote Habermas. He writes, "We must not understand basic rights or Grundrechte, which take the shape of constitutional norms, as mere imitations of moral rights, and we must not take political autonomy to be a mere copy of moral autonomy. Rather, norms of action branch into moral and legal rules." End of quote. Since even basic constitutional norms, such as respect for the dignity of the person, need to be promulgated in accordance with a specific jurisdiction in a specific time and place, they differ from moral norms, which are valid for all human beings at all times and places. Moral principles, such as respect for human dignity and equality, do not dictate a specific constitutional content, but all constitutional basic norms entail moral principles of respect for persons, their equality and dignity. In negotiating the relationship between general human rights norms as formulated in various human rights declarations and their concretization in the multiple legal documents of various countries, we may invoke a distinction between a concept and a conception. I know this may seem like philosophers quibbling, but again, this is an extremely important distinction, also involves this theory of justice. We can differentiate between concepts such as fairness, equality, and liberty, and conceptions of fairness, equality, and liberty, which would be attained as a result of introducing additional moral and political principles to supplement the original conception. Let me explain. Should justice be defined as fairness, as Rawls had argued? This is a concept of justice. Or should it be decided, as Marx argued in the Gotha program, from each according to his abilities, to each according to his needs? These are general concepts of justice. To be able to make a case for one or another concept of justice, we need to introduce some further claims about security, human needs and wants, the structure of the basic subject of justice, and the like, to supplement our original concept of justice. Now, how does this distinction help me with the issue of what is the relationship between rights as articulated as principles in international treaties and rights as constitutional rights? Applied to the question again of how we move from general normative principles of human rights as enshrined in various covenants to specific formulations of them as enacted in various legal documents, this suggests the following. These documents, I submit to you, formulate core concepts of human rights, which would be part of any conception of valid constitutional rights. So there is a range of legitimate variation between a concept and a conception, and this legitimate range of rights can be determined across democracies in the following way. Let me give again an example. Take as fundamental a principle as moral equality of the person. Okay? The moral equality of the person assumes a justiciable meaning as a human right, the right to human equality, once it is posited and interpreted by a democratic lawgiver. And here, a range of variation can suggest itself. For example, again, while equality before the law is a fundamental principle for all societies observing the rule of law, in many societies such as Canada, Israel, and India, equality before the law is considered compatible with special immunities and entitlements which accrue to individuals in virtue of their belonging to different cultural, linguistic, and religious groups, so-called group-differentiated cultural right. For societies such as the United States and France, with their more universalistic understandings of citizenship, these multicultural arrangements would be considered completely unacceptable. At the same time, for example, in France and Germany, the norm of gender equality has led political parties to adopt various principles of parité, namely that women ought to hold public offices on a 50-50 basis with men. By contrast, within the United States, gender equality is restricted, protected by Title IX, which only applies to major public institutions such as schools and hospitals, does not apply to political parties that do not receive federal funding. How do we justify this range of variation, even in a basic norm as equality? Are we ready to say that Canada, Israel, and India are wrong in developing multicultural citizenship norms, and that citizenship must be universalistic as France, the United States, and let's say Turkey has it? And how do we interpret a norm like gender equality? Philosophically, James Nichol is one of the few authors who have noted the multiplicity of levels at which the rights vocabulary can function, and who have tried to explain the translation of the language of normative principle to the justiciable right claim. Nichol writes, the rights vocabulary can be used at any one of these levels. For example, one might talk at the grand level of the right to equal respect, at the middle level of the constitutional right to due process, and at the application levels of a statutory right to have 30 days to prepare for a hearing. And here you will have the range of variation here. But the vocabulary of human rights is used most typically, he continues, at the middle level. It is used by nations or international organizations to outline in broad but still fairly definite terms what grander principles of morality and justice require in one country or era. In other words, there is a legitimate variation in the interpretation and implementation of such a basic right, even as that of equality before the law. But the legitimacy of this range of variation and interpretation is crucially dependent upon the principle of self-government. So this is the crucial link between democracy and human rights in my argument. My thesis is that without the right to self-government that is exercised through proper legal and political channels, we cannot justify the range of variation in the content of basic human rights as being legitimate. Unless a people can exercise self-government through some form of democratic channels, the translation of human rights norms into justiciable legal claims inequality cannot be achieved. So, the right to self-government is the condition for the possibility of the realization of a schedule of democratic rights. Just as without the actualization of human rights, self-government cannot be meaningfully exercised, so too without the right to self-government, human rights cannot become justiciable entitlements. They are coeval. That is, the liberal defense of human rights as placing limits on the publicly justifiable exercise of power needs to be complemented by the civic republican vision of rights as constituents of a people's exercise of public autonomy. To use another Kantianism, Without the basic rights of the problem, Republican sovereignty would be blind. Without the exercise of collective autonomy, rights of the person would be empty. I think many of you are familiar, let me just add something here, with the famous debate in political philosophy between liberalism and civic republicanism, and the attempt to interpret basic rights as, in some ways, preceding the formation of the political order, or John Locke, or Rousseau's claim that it really makes no sense to talk about basic rights until the contrat social is formed. What I have tried to do here now is I'm presenting an intervention, an argument, that is linking crucially the very concept of a basic right, which implies both a moral principle and a justiciable claim, to the exercise of democratic sovereignty. I am linking them together in an attempt to really basically say this traditional dichotomy between liberalism and civic republicanism is not helpful. So democratic iterations then are complex processes, let me go back one, of public argument, deliberation, and exchange, through which such universalist rights claims are contested and contextualized, invoked and revoked, positioned and repositioned throughout legal and political institutions. Every act of iteration involves making sense of an authoritative original in a new and different context through interpretation. The antecedent thereby is reposited and resignified, meaning is enhanced and transformed. Conversely, when the creative appropriation of what is considered authoritative ceases or stops making sense, then the original loses its authority as well. That is to say, democratic citizens must reinterpret and reappropriate human rights principles to give shape to them as constitutional rights, and if necessary, to suffuse constitutional rights with new content. Nor is it to be precluded that such constitutional iterations may themselves provide feedback loops in rendering more precise the intent and language of international human rights declarations and treaties. Such processes of democratic iteration produce a messy awareness of the difficulties and attractions of world citizenship. Democratic iterations, when we look at them sociologically, occur throughout civil society and the public sphere in diverse sites. In constitutional democracies, the courts are the authoritative and primary site of norm iteration through judicial interpretation. That's what the courts do. But the interaction between domestic and transnational norms can also take place through the contributions of other organizations such as NGOs and INGOs, such as Amnesty International and Human Rights Watch. These organizations are active participants in norm elaboration and in actually making clear what treaty obligations suggest. And the third site of democratic iterations are those provided by civil society groups, movements that are also potential participants in transnational norm interpretation. Now, in the final concluding sections, let me try to elaborate this notion of democratic iteration, which, as Rainer noted, has been in my work for a while, and I'm now pushing it a few steps further than I have been able to do in my previous work. And I want to come here now to three contemporary arguments, which I think are extremely helpful for me in further elaborating this notion of democratic iterations. Again, the fundamental insight here is to move beyond the binarism of the cosmopolitan versus the democratic, the international and transnational versus the civic republican, democratic sovereignty versus human rights law. A first argument has been presented by Alan Buchanan in a recent article. Alan Buchanan does not explicitly use the concept of democratic iterations or the discourse theory of legitimacy, but upon a closer look, his model is really a Habermasian model. He begins with the observation that, quote, the more seriously the international legal system takes the protection of human rights, and the more teeth the commitment has, the more problematic the lack of a credible public justification becomes. So what is a credible public justification process when a state interprets or attempts to reinterpret a basic human right? Buchanan argues that we should focus on what he calls the epistemic virtues of institutions through which the norms are specified, contested, and revised all the time. Now, given that human rights norms are necessarily abstract, argues Buchanan, and I agree with him, they need contextualization and specification. But to avoid the parochialism and a free-for-all pluralism, we need institutional processes of a certain epistemic quality. And what is the epistemic quality or virtue of such institutions? That they show a mode of practical reasoning that are publicly accessible and justifiable. In other words, when courts give a particular interpretation of a basic human right, and there are great variations across democratic countries. Consider, for example, the US fundamentalism about free speech, as opposed to the fact that in France, personal insults, even in an academic context, can be regulated as violations of the use of free speech. In the United States, this kind of thing is inconceivable. Now, what is it that can justify this range, again, even in the articulation of a fundamental norm, such as free speech? I know the lawyers say margin of appreciation, but what I'm trying to understand as a philosopher is not why the court says margin of appreciation, but what justification is there for us to accept that there may be a legitimate variation when we are trying to articulate some fundamental human norms. And Alan Buchanan's argument in this instance is that we can, in fact, see such range of legitimate diversity in interpretation of norms as an exercise of public practical reasoning. And public practical reasoning is manifested by these institutions that have epistemic virtue. Let me take one quote from him. Institutions that contribute to the articulation of human rights norms ought to provide venues for deliberation in which the authority of good reasons is recognized, in which credible efforts are made to reduce the risk that strategic bargaining over raw power will not displace rational deliberation, in which principled contestation of alternative views is encouraged, in which no points of view are excluded on the basis of prejudicial attitudes towards those who voice them, and in which conclusions about human rights are consonant with the foundational idea that these are moral rights that all human beings now have, independently of whether or not they are recognized. End of quote. Such epistemic virtues, as posited by Alan Buchanan, are the virtues of a democratic public sphere and of deliberative sites in the judiciary, civil society, and political representative institutions. Since the contextualization of human rights norms entail processes of public practical reason, and since states cannot simply hide behind the shield of sovereignty, what we are looking at then is a transnational conversation of practical reasons that toggle back and forth between the moral and the legal concept of human rights and their supporting arguments. Now, Anne-Marie Slaughter has called such dialogues among the courts transjudicial communication. The courts around the world, she argues, recognize that a global set of human rights issues are to be adjudicated upon in colloquy with one another. Such recognition, she writes, flows from the ideology of universal human rights. The premise of universalism, however, does not anoint any one tribunal with the universal authority to interpret and apply these rights. Collective judicial deliberation, she continues, through awareness, acknowledgement, and use of decisions rendered by fellow human rights tribunals, frames a universal process of judicial deliberation and decision and approval. Anne-Marie Slaughter, as I'm sure many of you know through her work, has been an enthusiastic and able advocate of the new world order of global constitutionalism and judicial internationalism. Even if we may not share in her political optimism about these processes, and it's becoming increasingly difficult really to fully share in them, she's undoubtedly correct in calling our attention to the emergent world of transjudicial communication. What I'm trying to suggest is that processes of transjudicial communication can be seen as forms of practical reasoning as well, insofar as they involve, as Buchanan notes, practices of reason-giving, deliberation, and argumentation. But let me come back to a question I raised at the very beginning. What about the skeptic's point that the typology of transjudicial communication, Alan Buchanan's argument that rights justification is a form of practical reasoning, completely flies in the face of states' practices of so-called rights, reservations, understandings, and declarations? This is a legally accepted practice. Doesn't that simply take the teeth out of human rights observance? Here, my colleague Judith Resnick has observed that treaty ratification processes now no longer center upon what she calls a singular formal moment of ratification through a monovocal nation state. That the play between the monovocal and the plurivocal nation state is going to be very important. And I will try to explain now why she does not see this as a singular formal moment. Increasingly, cities, states, municipalities, and not just nation states, are themselves incorporating major human rights treaties into their charters. The city of San Francisco, for example, has adopted CEDAW, although the United States Senate has not ratified CEDAW. Okay? Sao Paulo, Brazil, has accepted CEDAW as part of its charter. Oregon has incorporated the Universal Declaration of Human Rights. Resnick names these processes of legal seepage, the way water flows, it seeps through, or law by affiliation. These processes occur at sites below the centralized political authority of the state, and they testify to this notion of law by affiliation. Such affiliations at the local and federal levels multiply the sites at which transjudicial conversations can occur and show how, even in the face of national recalcitrance and resistance to CEDAW, for example, a human rights discourse across national and local boundaries takes place. Resnick's most innovative contribution, I believe, is to suggest that rights themselves can be viewed in analogy to doctrines such as margin of appreciation. Resnick argues, for example, that in Bangladesh in 1997 withdrew reservations to CEDAW, which were earlier based on the conflict between Sharia law and the convention. In other words, we need to look at the states in relation to these conventions as a dynamic and multiple process that changes over time. Jordan withdrew a similar objection to a woman's right to independent residence and domicile other than that of her husband in 2009. And here are some examples from Europe. Sex-based differences in the military has led countries such as Australia, Austria, Germany, New Zealand, Switzerland, and Thailand to place reservations on Seyla, many of which have been withdrawn, many of which have withdrawn their caveats. Resnick is not forgetting either to the corrosive effects that RUDs, reservations, understandings, and declaration have, or nor the potentially opportunistic uses that can be made of the famous doctrine of appreciation, margin of appreciation in the courts. Yet she sees these models as offering what are called mediated participation. That is, to see the process of treaty ratification and membership also as a process of iteration and conversation and law by affiliation, and not just as a one and all time thing that you either access the treaty in full or you don't. And she concludes that these processes capture the idea of polities joining in commitments that both acknowledge their independent identities while imposing reciprocal obligations. So, I shall move towards a conclusion. As these final discussions indicate, whether we emphasize the epistemic virtues of practical reason at work in the deliberative institutions, including the courts of a democratic society, as Ella Buchanan has done, the transjudicial conversations of judges, as Anne-Marie Slaughter does, or law's affiliation through decentering the nation-state paradigm, transnational treaties, practices, and institutions, I have argued, can enhance rather than diminish democratic deliberation and rights discourse. While not sharing the skepticism of realist state theorists such as Robert Dahl, I'm also unable to share in the enthusiasm of global constitutionalists such as Jürgen Habermas. It is within bounded and across polities, which may be nation-states, multi-ethnic or multicultural democracies, binational federations, or constitutional post-national entities such as the European Union, but it is within and across bounded polities that democratic iterations can occur. These boundaries are porous, permeable, and active sites of transnational conversations and interactions. But it is this radical fact of interdependence and transnational affiliation that contemporary legal cosmopolitanism seeks to elucidate, and what I have tried to show in this lecture is that many of the binarisms which are circulating in contemporary thought can themselves be either softened or eliminated. And thank you for listening. I very much look forward to your feedback on this.